Hello, everyone. I think the computer is fine now. I hope everybody's seeing me and listening to me. My name is Alberto Murray. I'm coordinator of the Legal Affairs Committee and the legal vice president of the Brazil-Canada Chamber of Commerce. The Chamber of Commerce Brazil-Canada is an independent and non-profit organization that has been promoting since 1973 business, cultural, and technological exchange between Brazil and Canada. Located in São Paulo and Montreal, it brings together people, companies, public and private institutions from various branches of activities in both countries. The Brazil-Canada Chamber of Commerce services are products that are tailor-made, modern, and innovative, providing visibility and networking to the members in Brazil and in Canada. The Local Affair Committee was created to promote the exchange of information on both laws, promoting the discussion of national and international issues, and therefore enabling its members the level of information required to make business decisions. The webinar led by our legal committee will present the Brazilian Economic Freedom Act and its impacts on the agribusiness sector. We are honored today to have three qualified lawyers who will address important points regarding this new Brazilian law. We have with us today Renata Nobre from Fonseca Brasil Advogados, Rodrigo Cotta from Kincaid Advogados, and Elias Medeiros Neto from Tosini Freire Advogados. So at the beginning, each of the participants will have 15 minutes to make the exposition and to present themselves. And after that, the seminar will be open for discussions and questions, answers, and debates. You can send your questions and comments in the chat, and the speakers will be glad to answer once they have finished their talk. So I pass the word to Renata Nobre to start her presentation. Thank you, Renata. Thank you for all of you for being with us today.
Hello, everyone. Thank you so much, Alberto. I think I'm just going to start off with my own presentation. I think for the presentation of the role will be played first by Elias, I think, right? So, yeah, right, Elias?
Yes, I think I was the first.
You are the first one. I remember that. But if you want, yeah, okay. So I'll be just no. I think we better follow what we agreed, right? Maybe you better do your presentation and then after you all
Okay,
start.
so I'm sorry, Elias, but well, the program today was the other way around. So, but feel free to
It's
start.
okay, no
No worries
problem.
about that, because we agreed that my presentation will introduce some general aspects of the law first, and after Renata will focus the presentation environment, right? So
Yes,
this is
we
not a
changed.
problem. Oh, okay. So
No, it's okay. Go ahead, Elias.
okay, thank you very much. Good afternoon, everyone. I have my slide here, and thank you very much for Mr. Alberto Murray. Thank you very much, Ms. Renata Nobre. Good afternoon, everyone. First of all, I would like to thank the Brasil-Canadá Chamber of Commerce for the kind remembrance of my name for dealing with such a relevant topic. Congratulations on the initiative of the event. I congratulate Mr. Murray for the relevant work he performs in legal studies aimed at agribusiness, and thank him for chairing and mediation this event. It's a great honor for us. I greet the other colleagues who will make their presentations. They are very expert lawyers in this field. I am a partner in dispute resolution at Tosini Freire Lawyers. Since 1976, Tosini Freire has distinguished itself as a premier full-service law firm by consistently providing legal services to domestic and international companies in a wide variety of business sectors. The firm operates in several areas of law and seeks to provide extensive legal support to its clients with the corporate environment, with a strong area of expertise in agribusiness also. It has more than 500 lawyers and more than 1,000 employees with 7 offices: São Paulo, 2 offices, Rio de Janeiro, Brasília, Porto Alegre, Caxias do Sul, Campinas, and a representative office in New York. I was certainly expressly overwhelmed with the possibility of managing the topic, as this challenge takes me to the area of law that goes beyond my academic studies routine, given that I am a frequent scholar on issues of Brazilian civil procedural law. I have postdoctorate, doctorate, and a master's degree in civil litigation. So for me, it's a great challenge to talk and debate something related not exactly with civil litigation. Well, with our agenda, I was responsible for introducing general aspects of the law. The 2019 Economic Freedom Declaration law had a strong purpose of declaring rights and guarantees in favor of the exercise of economic activity in Brazil, with a strongly liberal bias and aimed at promoting legal security in the relationship of companies with the state and with respect to agreements. The law number 13874 of September 20, 2019 aims to establish rules for the protection of free enterprise and the free exercise of economic activity. The law is applicable to civil, business, administrative, economic, urban, environmental, and labor law. However, it is not applicable in general to tax law, for example. The law establishes a master principle: the need for rules that deal with private economic activities must be interpreted in favor of economic freedom, good faith, and respect for agreements, investments, and property. General principles that must be respected according to the law are: first of all, freedom as an important guarantee in the exercise of economic activities, presumption of good faith of the individual or company in relation to the state, the exceptional and subsidiary intervention of the state on the economic activities, and the recognition of the individual's vulnerability or company's vulnerability in relation to the state. The main rights to the companies or individuals according to the law are to develop a low-risk economic activity without the prior release by the state, to develop economic activity at any time or day of the week, including holidays, without additional charge, provided that the specific law applicable be observed, to define freely in unregulated marks and with a listed target the price of products and services, to receive equal treatment from the state in related with the exercise of acts of release to economic activity, observed previous precedents in similar cases, the presumption of good faith in the acts practiced in the exercise of economic activity, unless there is a law provision establishing clearly how is the right conduct that's expected, respect for agreements negotiations between the parties, given that the review of contracts must be considered an exception, time limit for the state to approve requests that have been submitted by individuals or legal entities in order to obtain the release of an economic activity, no abusive compensatory or mitigation measure or provision be required in the context of impact studies or other releases of economic activity, such as for areas not directly impacted by economic activity, for example, or which are not reasonable or not proportional. The law also establishes some kind of guarantees, and these guarantees are related with the conducts that state must avoid, such as to create a market reserve by favoring in the regulation an economic or professional group, to write statements that prevent new national or foreign competitors from entering the market, to demand technical specification that is not necessary to the desired purpose, to the target, to write statements that prevent or delay innovation, to increase transaction costs without demonstrating benefits, to introduce limits on the free formation of business companies or economics activity. Other relevant aspect of the law is the need for prior preparation of regulatory impact analysis. When the state studies proposals for editing acts with strong interest to economic agents or users of the public service, the main objective is to gather information and data on the possible effects of the new normative act to verify the potential economic impact. The law also emphasizes the autonomy of the legal entity in relation to its partners and administrators. This is a relevant issue because the civil code in Brazil doesn't have a clear provision in the same way. So this is a very important innovation with this law of 2019. And most important, one positive aspect is the law also emphasizes the autonomy of the legal entity in relation to its partners and administrators. But one positive aspect is, in this topic, is the provision related with requirements for disregarding of the personality of the legal entity, given that the law clarifies certain terms that the civil code had already used in the Article 50 without, however, the same precision. Now, we have the definition of the term personality abuse, misuse of purpose, as the use of legal entities for the purpose of harming creditors and for the practice of illicit acts of any nature. And on the same way, we also have the definition of the term equity confusion as the absence of a real separation between the assets of the company and that of the partners and administrators. Besides that, the law established the concept that the mere existence of an economic group without the presence of the above requirements does not authorize the disregard of the personality of the legal entity. The law, in connection with civil topics, presents rules for interpreting agreements considering 1. Behavior of the parts after the closing. 2. Uses, customs, and market practice. 3. Good faith. 4. Better interpretation in favor of the party that did not write the agreement. 5. Notion of reasonable negotiation by the parts on the issue discussed, considering the main aspects of the deal and its market. The law also emphasizes that the parts may freely agree on rules of interpretation. So the topic, for example, varies in the agreements is a much relevant topic for understanding of the clauses in general. Other relevant aspect of the law is the need for prior preparation of, this is other points of related with contracts. So another point according to the law is the need for contracts. Observe the social function and private relations to be reviewed with exceptionality. This is the most important thing according to the law. The law is very worried with the need to observe the terms of agreements. So review of the agreement here is treated as exceptionality matter. In civil and commercial relations, be assumed to be equal and symmetrical. Beyond that, the agreements may provide for objective parameters for the interpretation of the negotiation clause and their assumptions for review or resolution, division of risks, and again, exceptional situations for contractual review. Other relevant aspect of the law is the intention to promote a more efficient litigation involving the state. The state is incentivized as a desirable responsible litigator to avoid appeals against decisions where there are already judicial precedents. The state also is incentivized to arrange procedural agreements in order to contribute to the process more effective and efficient. So, in my point of view, we have potential positive effects for agribusiness in general. You have a liberal tendency of the law, the first one. The second one, principles that give prestige to economic activity, possibility of setting prices of products and setting working hours of the employees, observing the legal limits, prestige to what's negotiated between the parties to the agreements, prestige to the terms of the contracts, we can say. So again, the possibility to review agreements is possible according to the civil code, but must be studied as an exceptional thing, exceptional matter. We have exceptional situations of contractual review. So this is a very important point of this law. Regulated interference by the state in economical activities is a subsidiary interference and incentive to business activity in general with more legal certainty. So I thank you for the kind invitation. I hope I have collaborated on the topic and I am at your disposal. Thank you very much. I think Renata, now we will start.
Yes, now is my turn. Okay, good afternoon, everyone. I want to thank once again CCBC for the invitation, for the really kind remembering of my name to be a part of it. And I'm really honored to be here, to be participating on this event. And today I'm gonna speak about, will you play the, yes. Yes. Okay. Yeah. So today I'm going to talk to you about the Brazilian Freedom Act and its impact from an environmental perspective. I chose these topics because, in my opinion, they are very sensitive and very strategic for the companies of the agribusiness sector, which in an overview, it is very important to analyze this law under this perspective of the environmental. Okay, so I'll start here telling some data about the agribusiness in Brazil. So currently, agribusiness is one of the most important sectors of the Brazilian economy, as we all may know from now. So it represents the 1/3 of the gross domestic product, and as well as being a major generator of jobs in our country. So in addition to that, it is of great importance for the global food security, since about 1.5 billion people are fed daily by the Brazilian agricultural production. So according to the Brazilian Agriculture Research Corporation, named in Portuguese as Embrapa, the protected native vegetation occupies 61% of the Brazilian territory. So in order to protect these resources, Brazil has one of the most complete environmental legislation in the world. So the activities inherent to the agribusiness production to the agribusiness production line are mostly linked to the use of natural resources as water, land, air, fauna, and flora. And therefore, such activities must submit to the criteria established by the Brazilian environmental standards and intense control of activities regulated by the environmental agencies. Ingrid, I just remember about you. I have to tell you, yeah, to move on. I think you can skip to the next one now. Okay. So, however, while compliance with the environmental regulations is absolutely essential for the sector's sustainability and business longevity, the negotiations with the environmental agencies and the excessive bureaucracy faced by the entrepreneur make the results ineffective and harm the business environment for both sides, right? Such as we can see that the agriculture sector is so important to the country. We must evaluate if the rules, the norms we already have are giving the country these results. Yeah? So under this scenario, the Economic Freedom Act, among its various contributions, provides new legal provisions that aim to reduce bureaucracy and assist economic activities developed in Brazil. And among them, agribusiness ventures, since they need to go through several authorizing producers, procedures, and environmental agencies. You can go ahead, Ingrid. So the law favors the simplification of administrative procedures, reinforces rights to the free exercise of economic activities and free market guarantees, as well as defines some criteria, I would say, and limits of abusive requirements of public administration towards entrepreneurs in Brazil. Okay, you can go ahead. Yes, thank you. So now I'm gonna present to you some important innovation brought by the Act, from an environmental perspective. Well, at first, it should be noted that the law brings in its first article an express statement that the provisions of this law must be observed in the application of the environmental protection rules, clearly validating its application to this field of law in Brazil. So this is very important, first of all, because environmental laws, as I'm always repeating that, it's so sensitive to manage those laws and business about that will bring environmental impacts, that people are always confused about the changes on the law that will bring some simplification or some, it's not that it's releasing or decreasing the protection, but it will simplify the procedures, and it leads to a doubt that if it is even possible for the environmental rules. And so if it's not clear on it's not really explicit on the acts or laws, it always leads to this doubt about its application. But in the first article of the Economic Liberty Act, it brings the absolute clear rule telling that all the law must be applied on the field of environment law, okay? So after that, the law declares a new principle, the good faith of the private individual towards the public authority, which determines that the business person must have the presumption of good faith in the acts practiced in the economic activity. So in cases of doubt, Thus, this entrepreneur must be presumed acting in good faith, not in bad faith. And since this is so simple, it is just a simple change brought by this law, but in the practical experiences, it is already changing a lot, because what happened is that, Ingrid, you can, no, it's okay, you stay there. And it changes a lot because since it was not previewed by any statement, any law, naturally the entrepreneur sees it an outdated overview of the investments in agribusiness. It will bring to this entrepreneur a misinterpretation, a bad view that he's there just to use the environment resources without having this responsibility about finding the best way to deal with that, to control the impacts of his business. And it will lead to a very more bureaucratic negotiation with the public sector in Brazil, because they usually prejudged the entrepreneur as in bad faith. This happened a lot. This is still happening, but this law comes to bring this overview, this statement to show that, first of all, the entrepreneurs, the investors, they must be seen as in good faith. Even if he shows a wrong document or something different may happen, he has to have the opportunity to explain, to fix the problem in a very fast way, not just paying fees or being, like prejudged as a bad entrepreneur, as a bad person in economy. Okay. So with this explicit legal determination that the presumption of good faith of the entrepreneur should prevail, a greater effort is required from the public authorities in Brazil to dialogue with the entrepreneurs, seeking to better understand the aspects of the business under analysis, enabling corrections to be made more quickly, and not imposing excessive penalties for erroneous presumptions about the entrepreneur's objectives. So lately, there has been growing investments in environmental conscious technologies and practice that bring sustainable development to agribusiness in Brazil. So the environmental sustainability favors not only the environment, but also can increase the productivity of farmers and companies. So it helps to decrease future expenses. So nowadays, the sustainability is a goal for everyone. So especially, and we would say mostly to the investors and entrepreneurs now, since it is like an international goal for the companies to move to this way. So it is not reasonable to these entrepreneurs in Brazil still be considered as in bad faith or as only interested in take the natural resources. So it must be checked case by case. It cannot be an overview interpretation by the public sectors as it was happening. This is why this law brings this new right to the entrepreneur, because it was really an obstacle in the practice. So the provision of this new principle is essential to overcome an outdated view of the responsible exploitation of the environment. In a scenario that I brought to you already, this is no longer possible for entrepreneur to be presumed guilty of violating environmental regulations. So besides the Economic Freedom Act, besides that, I want to tell you about some other points that are important points brought by the law. The Economic Freedom Act defines that the companies that Ingrid, you can move. Yes, thank you. That the companies that require public release acts, such as licenses, authorizations, concessions, permits, and others, from a public administration entity, must have the certainty that after all the necessary documents there for the analysis are presented, a deadline must be given. And if the deadline expires without a conclusion, the application will be considered tacitly approved, except for the cases explicitly forbidden by the law. So in this point, it is important to emphasize that although the law mentions that licenses should also be impacted by the tacit approval if the agency does not respond within the deadline, it is clear that this provision does not cover environmental licenses, because for this kind of licenses, there is a legal prohibition for tacit approval, according to the Complementary Act number 140, 2011. So what I mean on that is that the law brings a lot of public acts, public release acts, which must follow this rule of the tacit permission, the tacit approval. But it is, in the end of it, it is clear that even if there is a specific law which forbids this tacit approval, it will not be covered by the law. So nowadays, the only environmental act which is explicitly forbidden by a law, it is the environmental licenses. But other environmental acts are not forbidden. So the other acts, such as authorization for vegetation suppression or other grants, and beyond the environmental licenses, would be under the deadline rule. Okay, so because this is a general, since it is a general rule and established that all authorizing acts of economic freedom should apply these rules, only if there is not express preview, it will be forbidden. So it happens nowadays only for the licenses, okay? So, but I must emphasize too that this point is still controversial, and regulatory acts are expected to define which environmental acts could in fact be subject to a certain rule of implicit release, given the sensitive condition of this public environmental release acts. So finally, the last point I want to tell you is that the law determines that the public entities may not condition abusive compensatory measures as part of environmental impact studies, specifically those not directly affected by the economic activity. Ingrid, you can go on. Oh, no, come back a little bit. Yes, thank you. So what I mean is that this statement provides important legal certainty, considering that Brazil has many social and infrastructure problems. And in many cases, it is not rare to see that environmental agencies require as compensatory measures for environmental impacts investments that have nothing to do with the project, but represents a way of meeting local needs for improvements that the state, the government, was unable to provide until then. So the law comes to clearly block this kind of abuse, which is usually made in the beginning of the project, in the release process of the project, which the entrepreneur is vulnerable, trying to get a release on the public entity. And then for that reason, they end up accepting those abusive tasks from the public entity, which now from this law, it is not going to be possible anymore. So just closing my points, Ingrid, you can go ahead. Thank you. As far as we can see, the strategic and sensitive position that the environmental perspective has been receiving in the recent years, a careful analysis of new Economic Freedom Act rules and its impact in the agribusiness is mandatory. So since this economic field operates mostly using natural resources in its production lines, it is even more important for us to understand this point of view. So we can conclude that the Act brings important contributions for the reduction of bureaucracy and strengthening the economic freedom of the entrepreneur, bringing a lot of new rights for them to be used in practice, and because they suffer from excessive and unnecessary obstacles from the national public administration in environmental procedures. Well, thank you very much. I hope I was able to explain everything that I meant to, and I'm gonna pass the presentation for my next colleague. Thank you very much for your attention.
Thank you very much, Renata. My name is Rodrigo Cotta, and I'm a partner at Kincaid Mediviana, which is a firm with 89 years old, very traditional, with offices in Rio de Janeiro, São Paulo, Vitória, and Brasilia. And we have practice in litigation, arbitration, tax, corporate, labor, among others, in the fields of international trade, agribusiness, and several others. So I will put my presentation here. Just a moment. Okay, so I will talk a little bit about the impacts of the Brazilian Economic Freedom Act in agribusiness and its importance during the COVID-19 pandemic. As you know, on March 11 of the last year, WHO declared the pandemic due to COVID-19 situation. And on the same month, 31, there was a joint statement by FAO, WHO, and WTO, in which all these entities expressed their concern about how the places would fight against COVID situation, and also expressed their concern to keep the food supply always open. In Brazil, the federal law number 13979 was approved on February 6th of the same year, even before the WHO declared the pandemic situation. So the law provides several rules to fight against COVID situation. And such law also provide that the president would issue a decree listing which activities would be qualified as essential. Just a moment. Sorry. And in accordance to that law, the president issued the federal decree number 10-282, which entered into force on March 20. And of course, the president included the agribusiness industry as an essential activity. And in paragraphs 2nd and 3rd, he also included the transportation and circularization of employees to keep the food supply always running. The main goal of the essential activities was to prevent a potential breach of chain of service, acquisition of goods and supplies to confront COVID-19. This is because Brazil is almost the size of Europe, and the idea was to bring uniformity to avoid the breach of the chain of production of food. However, on April of last year, the Supreme Court decided that the states and cities could also regulate the acts to fight against COVID situation. And the main grounds for that was, as I said, since Brazil is a large country, the Supreme Court understood that each state should have the opportunity to deal with the situation in accordance to their specificities. So, but as you may see here, the Supreme Court also decided that the decree should be issued in accordance to WHO recommendations. Based on these precedents, cities and states issued several decrees, and some of them even issued decrees in which the essential activities were closed, which bring several risks for not for only for the agribusiness, but risk of shortage of food. Nevertheless, this kind of prohibition was against the Economic Freedom Act. Mainly in the Article 3rd, this act bring the rights of every person and company to develop economic activities without undue interference of the state, including work on during the weekend, holidays, and this was very important for keep the agribusiness working. And against the decrees that issued by the cities that closed the essential activities, I will bring two precedents in which the companies file lawsuits to prevent the state to the undue interference of the state. The first one is the writ of mandamus filed before the Court of Goiás. Palmeiras do Goiás, which is a city of Goiás, the state of Goiás, issued a decree in which the activities, even the essential activities, were obliged to reduce their capacity by at least 50%. And of course, this affected the manufacturing. This caused the manufacturing reduction of essential products. And against such decree, the company filed the lawsuit, request an injunction to work without any restriction. And the injunction was granted by the judge. And the grounds for this decision was the Brazilian Economic Freedom Act, federal law, and federal decree about COVID-19. And another precedent that I bring to you is also a writ of mandamus filed before the Court of São Paulo. The lawsuit was filed in February this year against a decree of the city of Araraquara, which prohibit the production, distribution, commercialization, and delivery of all products, including food. And this company have a distribution center in Araraquara. And although they don't have industry there, all the products should be transported to Araraquara, where the logistics of food would be made. And this decree, which basically closed the city, was very bring several harms for the other closed cities. So the company filed a lawsuit, and the injunction was granted to authorize the center to work even with the decree issued by the city. And as conclusion, although the Brazilian Economic Freedom Act came into force in the second semester of 2019, COVID-19 appeared right after it. So the impacts in agribusiness of several disposals of said act were not yet possible to be ascertained. In any case, this act, as I show you, provides several principles which were already taken into consideration by the courts of Brazil to keep the agribusiness industry working in the scenario of pandemic. And in the last year, agribusiness achieved a record of growth of almost 25%. And agribusiness was one of the most important sectors to grant adequate combat to COVID-19. And finally, Brazil continues to be one of the most important producer and exporter of agri products, presenting several benefits for foreign investments. Thank you very much, and I hope you enjoy the presentation.
Thank you, all of you, for your gorgeous presentation. I would like to put some questions. I'll start with you, Elias, as you were the first one to speak. So, in face of the law, the Freedom Act, Freedom Economic Act, uh, what do you see as a progress on the issue of disregarding of the personality of the legal entity?
Oh, perfect, Mr. Alberto Murray, and congratulations again for chairing and moderating this debate. Thank you very much. Thank you for the question. Undoubtedly, the issue of disregarding legal personality was dealt with in the law in order to honor the company's patrimonial independence in relation to its partners and administrators. As I said, the Civil Code of 1916 in Brazil, in this Civil Code was a provision, Article 20. And in the Article 20, the independence between the patrimonial of legal entity and the patrimonial of administrators and the shareholders was very clear. But in the Civil Code of 2002, we didn't have the same provision. So now, undoubtedly, we have a reinforcement, as I say, with this law about the importance of this kind of independence. And in addition to clearly establishing that the mere existence of a business group is not a sufficient requirement for the application of the theory of disregard for legal personality, there is a clarity that the deviation of purpose of the legal entity occurs when there is a purpose to harm creditors and to practice something considered illicit. And other relevant point is that the equity confusion is also defined when there is no real separation between the assets of the company and its partners and managers. with constant repetitive payment by the company of the obligations of the partner or the manager or vice versa. So the presence of these requirements will be essential to disregard the legal personality in the courts after observing the necessary procedural requirements, and the procedural requirements are established in the Civil Litigation Code in Brazil.
Thank you, Elias. We now have a question here from a friend of mine, my classmate at university, and who is also one of the specialists in Brazil in agribusiness. As far as the legislation is concerned, welcome, Frederico Favacho. Fred is asking to the panelists, wouldn't all of the same effects of the Freedom Act be achieved under the pre-existing Brazilian legal environment? In other words, how much essential to the Brazilian legal framework do the speakers believe the Freedom Act was? Feel free to answer if you three want to comment that.
Okay, congrats, Frederico Favacho, for the question, and I know him, so thank you very much. It's a pleasure to meet you virtually, and it was a very good question. I can try to introduce the answer and to give a word for other colleagues, maybe to complete. I have a particular point of view about this law. I think with the pandemic period and considering the crisis of 2020 and the search for the state and companies and how to balance the functioning of the economy and preserve the health of all, it's very difficult to make a complete analysis of the law's effectiveness. I don't think we have enough statistics for that. But in my view, the law is well-intentioned, and we should give it more time to measure effectiveness. Any legislative change in Brazil, more structure, takes a little time to have concrete effects. And in this case, considering that the law is a declaration of principles and guarantees, in a sense, some other combinations are necessary, such as preparing the state to be less interventionist and less bureaucratic, for example. So we can check all of this in a next seminar with this same subject 2 or 3 years from now, after the pandemic, with Mr. Alberto Murray chairing again and moderation again other debate. But Renata and Rodrigo, feel free to complete, please.
Renata?
Don't let me alone with this question because it's a hard question.
Rodrigo,
Yes, I agree with you. I think.
Sorry. Oh, so sorry. I was trying to connect, but it was blocking. So Rodrigo, you can go and then I'll go after.
Just I agree with Elias. I think it's too soon to check where this law will have any effect or impact, because
I am here. Are you listening?
I can't listen.
Oh, I
think it's the internet.
He's frozen.
Yes.
So you can complement, Renata.
I can try. Okay. So yes, important for me to also reinforce what Elias just said. It is not yet, the long period of the pandemic has not yet allowed the practical effects of the law to be fully realized. But since 2019, when it was publicated, to me, in my opinion, in the environmental overview, and the environmental field, in the public entities, we can see a lot of difference already in the treatment of this entrepreneur. It is way more easy to negotiate and to have this view of the right of the good faith explicitly put by the law. It is a huge difference because we work mostly with the public acts release. So it brings a lot of difference, a lot of changes to this sector. So in this point of view, we can already see a lot less bureaucracy and a lot of rights of the entrepreneur being observed by the public entities already. So to me, it has a big difference. It was essential. It brought a lot of rights that were not even previewed or stayed by a law. It was too open by our legislation about what it is necessary to maintain for the entrepreneurs. And the law brought a lot of it, that there was a lack of information of this kind in other Brazilian rules. So to me, it made a huge difference.
Just to complement, we were discussing here before the panel how difficult would be to speak about law that after it becoming force, we have probably the most important crisis. And we know that in the litigation, especially, we have important rules that we use, but in the agribusiness is very recent yet. So we have some precedents in which, especially in respect to fighting COVID situation, in which we found the act being included in the decision. But I think we will probably see the impacts of the law in the next 2 or 3 years.
Okay, I have a question for you, Renata. Do you think that the changes brought by the law represents a decrease in the environmental protection rules in Brazil?
I don't think they do. Actually, in my opinion, the law brings important new rules and rights to improve the negotiation and to clarify the path for obtaining acts in the public authorities in Brazil, which it was before the law. It was very open, as I just said. It was very open how the entrepreneur must be treated in these public entities, and they ended up following this bad overview. They were prejudged, and a lot of these new rules brought the best relationship between the parts. So beyond the relationships, it brought the enforcement to the public entities to follow, to make some more effort to understand the business and the entrepreneur in its processes. So I don't think it represents a decrease in the environmental protection rules. It just makes a little more clear way for everybody to act and for everybody to get a result. Not to minimize any protection, but to, I forgot the word, viabilizar, but to, someone help me. I forgot how to say in English, viabilizar.
Feasibility.
No, viabilizar, to
To make it visible, yeah.
To make it happen.
Make feasible.
Yeah. Okay. Thank you. To make it possible, visible.
Feasible. To make feasible.
Oh, to make feasible. Okay.
Yeah.
So to make it feasible, to make it happen to get a better result. Yeah, to not to minimize the damages, but to simplify the path to get into these results.
Right. Rodrigo, on your slides number 9 and number 10, you described legal grounds for the injunctions to be granted. In those cases, specifically slides 9 and 10, there were other grounds that you could mention?
Yes, in all those cases, the companies had to prove that they were in compliance with all sanitary protocols. So their employees were in a safety distance, they were wearing masks, the place had alcohol for the hands, and etc. So for the injunction to be granted, we need to prove that. And the companies in Brazil, they are all in fulfillment of the recommendations of the WHO. So the judge taking into consideration that a lot.
We have a question here from Rafael Rocha to all panelists. Big players in the Brazilian agribusiness are improving results and regulatory attendance with good or even great management practice. For example, obtaining international recognition in standards like ISO 14001 environmental, ISO 45001 health and safety, even ISO 9001 quality, and others. Do you all believe the law could embrace new entrepreneurs and small farms in order to attend regulatory requirements and also improve results? Is it for the three of you?
I can answer that. I see, Rafael, in my opinion, yes, it can absolutely help those small and new entrepreneurs and small farms to embrace that, to be embraced by the law, because I think by the new recognition rights, establish new rights brought by this law, a lot of them will be just, they will have the information about how they can lead their processes since the beginning. So this is the difference, in my opinion. When you put the right laws, the right rules for everyone to understand before you even start your business. And this is, it's gonna embrace anyone that wants to do that. Yeah, to follow the rules, to be compliant, to be in compliance with the environmental rules and all the rules the law is bringing to us. So everybody which is not, they don't have any certification, you can just follow the rules, the national rules. They are even getting more and more specific, more and more open about that. Everyone, every entrepreneur that is interested in follow the rules just can get a good, I can say, previous consultation. It can start since the beginning, following this new criteria, getting his rights to be follow on the public organs and the public entities. And it is not just for the big ones, but it's also for the small ones. But since, of course, those entrepreneurs dedicate themselves to understand the law, to get this qualified legal consultation and understand their rights, understand their path, what they can do to better to open this dialogue with the public entities, it will follow a better way for sure.
And I would like, if possible, to add with this question that we must not forget the importance of the strong ESG movement. So without concern for the environment in general, agribusiness will not be able to obtain investments. And I think here in Brazil, we have much aware about that. And if it's possible, just to add somehow an important concept of the Frederico question, is that for my concept, there is the importance of emphasizing certain principles and concepts. So the same happened with the Civil Procedure Code, thinking about the guarantees that were read in the Federal Constitution. I mean, talking this because the question of Frederico was if the law was really necessary about declarations and guarantees, because somehow this kind of declaration or guarantee were in the other law, in civil code, for example, we had read some principles. So the law, I think, is important to emphasize some concepts in this part.
Alberto,
Alberto,
can I hear you?
You are, yes, you are in the
Oh.
silence. Okay.
Sorry. Elias, still with you. Regarding the contract law, in your opinion, what is the most relevant party of the law?
For me, I think the prestige to what was negotiated between the parties, prestige to the notion that only exceptionally the contract provisions can be revised. I emphasize this in all my presentation, and the possibility for the parties to establish in contract the main lines of the interpretation of the agreement with a wide possibility of negotiation, avoiding eventual and future problems in the application and management of the contract. So the various part in the agreement, for example, is very important. How the contract will be managed, how the contract could be interpreted. So I think this is a hotline, is a hot topic of this law.
Especially in the COVID-19 situation where we have several companies trying to breach the contracts and several lawsuits filed to maintain such contracts. So I agree, Elias.
Yes, good point.
Okay, Rodrigo, is it safe to affirm that there is a legal certainty in Brazil legal system when taking into consideration the issuance of decrees by the state governments and municipalities, which are clearly opposite to the federal laws and decrees?
Yes, there were only few cities that issued the decrees were clearly against the WHO recommendations and federal law. And the legal certainty, I think, was maintained by the courts, which in every democracy are also responsible to keep the appropriate system of checks and balances. Nobody was prepared for the pandemic. However, courts in Brazil are maintaining a reasonable attitude in combating COVID-19, especially avoid shortage of food and maintain chain of logistics for the agri products. I think yes.
All right. The question to you, Renata, is it possible to affirm that with the new law there will be have less litigation for agribusiness sector?
I think it can go the both ways. As I I just said, since now we have more clear rules about how to follow the path on the regulatory procedures on the public entities, it can also bring the entrepreneurs for the prior consulting, for the prior analysis that on his business, and it may avoid a lot of litigation, judicial litigation, I would say. It would bring to the efforts to this initial phase, which will be, I see a potential decrease on the litigation on this way. But on the other way, since it also brings new rights to the entrepreneurs, since they're not following the rights in the beginning, or not being I forgot the word again. If it's not gonna be respected, I remember, if the rights are not being respected even by the public entities, yeah, they will still have new judicial litigation for the agribusiness sector. This is never something that we can say it's gonna end, but I think for the law will bring both ways of resolution of conflicts.
Alberto, you are
you're muted again.
Oh, I pressed here, but it didn't work. Sorry. So we have a last question, unless someone from the chat will have some further question. But for you, Elias, it was mentioned that the state is encouraged to have more responsible litigation. Could you go over this topic and explain a little bit more?
Yes, the state is the largest litigant in Brazil, undoubtedly. So the law encourages the state to observe the judicial precedents already set and to avoid the interposition of delaying appeals in accordance with the Civil Litigation Code. In the Civil Litigation Code, you have a disposal that with the provision that we have to observe the judicial precedents is the article 927, 926, 26 and 27. And in addition, the law allows the state to make agreements with companies, including those of a procedural nature, to make procedures more flexible and seek more procedural effectiveness. For example, the state is encouraged to split debits and to facilitate payments, subject to certain legal requirements to make the process more efficient.
Good. Does anyone want to make any comment, or if someone wants to make a question? If not, I would like to thank you again, Renata, Elias, Rodrigo, for being with us today. I would like to thank the Chamber also, as always, for the support given to the legal committee. And of course, to all of you that have been with us in the audience. We used to conduct webinars at the legal committee almost every month. So I invite all of you to be attentive to the advertising that we make and be again with us in the next events. Thank you very much. Bye-bye.
Thank you. I have a ask. May I?
Oh, you have a question?
I would like to take a picture.
Oh, yes. Yes, please. Me too.
Right. Okay. Great. Thank you very much.
Okay. Thank you so much again, CCBC. Thank you, all my colleagues here, for the opportunity. I'm here, or I ended up forgetting to say, but our office is based in the north of Brazil. So I was going directly to my presentation. I forgot to say that. But thank you so much for the opportunity. And we'll see you, everyone, next time. Hope so. Stay safe, everyone.
Thank you very much.
Thank you, and it was a great honor. Thank you very much.
Bye-bye. Take care.